Well, thank you very much for that. And we will be having quite a transition now onto bonus disputes. And this is obviously a very different type of topic, but there is one thing that it has very much in common with the last talk, and that is that the Supreme Court has been keeping us on our toes. So whilst bonus disputes may be a familiar area for many of you, we thought it was worthwhile to revisit them in view of some jurisprudence we're going to discuss. So the short position is that there have been two significant Supreme Court decisions on contractual discretions in the employment context in the last 10 years. We're going to discuss both of those today. And we thought it was important not to jump into this debate halfway through. So we're going to begin by covering the developing principles of the law about particularly implied terms. We're then going to talk about the case of Braganza in the Supreme Court and also how that has been applied in later cases. We're then going to talk about the impact of Tesco and Usdaw, which is potentially very significant indeed. We're then going to address how far the trust and confidence arguments that have been developed in both the cases just mentioned are likely to reach. And then we're going to round off with two questions which are very focused on practicalities, because for reasons that will become apparent, it can be quite challenging to prepare particular types of evidence in these cases. And there is also a significant question about remedy, which is left open by the case law as it stands. So without further ado, I will now pass over to, literally, the painter, to Bianca to carry on with the principles.
So I'll be taking everyone on a whistle-stop tour of the history behind discretionary bonuses up into Braganza, and then I'll be handing over to James. Now, first stop on our tour is Clark versus Nomura. So for those of you who aren't aware of the facts of the case, basically Mr. Clark was a rainmaker and was dismissed about a month before bonus payday. The bank decided to award him a nil bonus, which, frustratingly, his desk colleagues were receiving bonuses of around 2.5 to 2.7 million. The largely ex post facto reasoning of the bank was in not awarding the bonus was Mr. Clark's dress and also the use of his cell phone at his desk. Bearing in mind this was in the 2000s. Now, the court reviewed a range of authorities considering discretion and where that discretion had been exercised arbitrarily or capriciously. These were then pulled together to come up with the well-known test of perversity or irrationality. Now, I've quoted the relevant part of the judgment. I won't read it out. But importantly, because the exercise of the discretion has to be done properly, it's not open for an employer to then decide ex post facto, well, this is my justification for what I had decided. Similarly, the employer could not rely on its own unjustified summary dismissal to avoid the consequences. Eventually, Mr. Clark was awarded around £1.3 million. Now, Clark was approved by the Court of Appeal in Hawklack, but I'm now going to skip ahead around 7 years, and our next stop is Keene versus Commerzbank. Now, Mr. Keene brought a damages claim for underpayment of bonuses in 2003 and 2004, and for non-payment of his bonus in 2005. About a month before the bonus payments were made, Mr. Keene was let go on the basis that his role was redundant. Well, that was the bank's assertion. Now, just to put this into perspective, in 2003 and 2004, Mr. Keene had received a bonus of almost 3 million euros. This resulted in him being in 2003 the fourth highest paid employee of the bank, and in 2004 the third highest paid employee of the bank. Now, you can see that this isn't necessarily going to be the type of case where the sympathies are going to lie with an employee that's saying they didn't get enough of a bonus because they only got 3 million. And I do think that did influence the court's decision to some extent. But Importantly, the court found that it wasn't its function to usurp the bank's discretion. The court was there to review the decision and to assess that the discretion was exercised in a proper manner. Specifically, Lord Justice Mummery said, "The test of irrationality is a very high and requires an overwhelming case." This is tempered somewhat by Lord Justice Moses's comment at paragraph 110, where he says, if an employee shows some evidence of perversity, the absence of an explanation from the employer will lend powerful support to this case. Now, that aspect and the evidential issues is also an interesting point that James will come onto in one of the last 2 points that we'll be addressing. Now, moving on to Braganza. Not sure how many of you know the facts of Braganza, but Braganza, as much as it comes up continuously in bonus cases, had nothing to do with bonuses. What had happened was that Mr. Braganza had been lost at sea. PP had investigated the death and had found that Mr. Braganza committed suicide. Because of that, the death and services benefit was not payable. His widow challenged this as an unlawful exercise of the discretion. Now, interestingly, this is the type of case where the Supreme Court was split on there was a significant diversity between the decisions on some of the facts. So, for instance, the majority found that there was a paucity of investigation, and on the evidence, the investigations team report and conclusion did not amount to sufficient cogent evidence to justify a conclusion of suicide. However, and very contradictory, minority took the view that it was an impressive report, both in the extent of the investigation on which they were based and the care with which it was complied with. Despite this dispute despite this diversion on the facts, the SC was in agreement as to what the relevant duty was. And this is what was summarized by Lady Hale at paragraph 24, and it's on the slide. Firstly, whether the right matters had been taken into account in reaching the decision. Now, in that regard, it's the well-known phrase of you don't take into account irrelevant matters, and you need to make sure that you've taken into account all relevant matters. And then secondly, whether the result is so outrageous that no reasonable decision maker would have reached it. Lord Hodge addressed how this would map over into bonuses. Now, importantly, it must be remembered that employment relationships are relational contracts, and therefore can't be equated to a standard commercial arrangement. It's therefore appropriate, or that was Lord Hodge's conclusion, to apply both limbs of the Wensbury test to the exercise of contractual discretions. Now, the scope of the scrutiny would differ depending on the nature of the decision. So, for instance, in Braganza, this was a fact-finding exercise, whereas Lord Hodge was of the view that with regards to the exercise of discretion, the case would be much more qualitative judgment. And in those cases, there would be little scope for intense scrutiny. But later in the judgment, Lord Hodge stated that there was no reason why an employer's decision-making should not be subjected to less scrutiny than a public authority making a finding of fact. Now, it's this specific part that we're going to look at our next stop in Patorell, where the court took this decision, or this section of Lord Hodge's dictum head on. Mr. Justice Singh said that he found it difficult to understand because in judicial review cases, the court doesn't substitute its own view, nor does it apply particularly intense scrutiny. It subjects the findings of the review to the standard test of irrationality or perversity. That's the standard that should be applied in employment cases. Therefore, while because of the relational element of an employment contract, there is more scrutiny than in a standard commercial contract, it's not any greater scrutiny, or it's not greater scrutiny than in judicial review, and it does not have all the public law factors and elements that are considered. Now, just for considering timings, I've included Watson versus Watchfinder, which is an example of a case that applied the Braganza principles in an option agreement. And in the case I will be ending off with is Fayetta. Now, Fayetta was a case where the individual was put on garden leave, and because they were on garden leave, they were held out of eligibility for the bonus. Now, Mrs. Justice Mulder accepted that Braganza applied to a decision on whether or not to have someone on garden leave. And importantly, it's not just the decision whether to place someone on garden leave, but it's also the decision on whether or not to keep them on garden leave. So that review process also has to take into account the Braganza principles. Nevertheless, Ms. Justice Mulder rejected the submission that the employer had to take into account the impact on the employee. And the important part here is that although in some cases certain matters may be relevant, in others they may not be relevant. Just checking that, yeah. Now, ultimately it was found that where there's no breach of the implied term of trust and confidence, there is no Ultimately, it was found that where there is a reasonable and proper cause, there will not be a breach of the implied term of trust and confidence. I'll now be handing over to James, who'll be looking at limitations of the Braganza principle.
Well, thank you very much. So we've seen here a number of cases which test out the boundaries of Braganza, and we've also seen Mr. Justice Singh sounding a note of caution about how this case really can be applied in the bonus sphere at all. It's particularly important to mention a line of cases that were not originally employment cases at all, but which came to have an impact on the law and which were addressed in the Usdaw decision, to which I'm going to go. So the first of these cases is a distinctly unusual case called Sherbanova and Forex Capital Markets. And this was a case of a retired Bulgarian schoolteacher who opened a trading account with a London house and made about $450,000 in 2 trades executed within a minute of each other on some quite complicated gold and currency trades. And the exchange called foul, and in particular they were particularly aggrieved because they thought that Mrs. Sherbanova was working as a front for either her son or her husband, both of whom had been subject to restrictions on the exchange. So they threw the weight of their terms and conditions at her, and crucially what they did, and I'm going to use the non-jargon term, they cancelled the trade. I'm not going to use the term of art. They cancelled the trade. And therefore she did not make her $450,000, and she brought proceedings. Now, there are a lot of issues in the case that are wholly irrelevant in the employment context. For example, one's about financial services regulatory law, which you'll be pleased to hear I won't be covering. But there was an argument that she ran, which was that the exchange was under a Braganza duty when deciding whether to cancel this trade or, for example, investigate further whether she had been involved in abusive trading, as they called it. And she said, well, I'm going to refer to BP and Braganza. And the judge, who may or may not have just been fed up with the number of arguments in the case, said, there's a short answer to this. They had a right to cancel your trade and they've exercised it. And thank you very much, that's it. So the reasoning is terse. The reasoning was then developed in a case called Taka Brittani, which is a commercial case which has rumbled on actually in various iterations. But what His Honour Judge Pelling found in that case is that, yes, he accepted after a lot of argument that there was potentially a so-called relational contract, so something slightly similar to an employment contract. But then he says, well, that doesn't lead, apologies for a typo. No, I didn't correct it. Anyway, that doesn't lead to the conclusion that it's necessary to imply a good faith obligation into the exercise of the power, that's the key word, on which the claimants rely. That is so because on its true construction, that power is an absolute and unqualified power for the reasons explained earlier. In consequence, you cannot imply a term inconsistent with the express term. Now, the significance of this line of cases was that they suggested that if you had contracts which did not use the D word, if they didn't have discretion in them, there was an argument open to employers, and in employers I include people operating captive vehicles, operating long-term incentive plans, etc., there was an argument open to them that actually Braganza doesn't apply here at all. We have simply exercised our contractual rights, and that's the end of it. And you could see various species of this argument. So, for example, term administrators could say, well, the wording of the contract is if you're dismissed, that's the position. You've been dismissed, we're entitled to take the employer's word for it, and we haven't exercised any discretion in cancelling your awards. We have simply exercised a contractual right. So that was a line of cases that crept into the skeleton arguments and so on you got in these cases. So we now have a dramatic move onto Tesco and Usdaw. Now, I think this is without doubt one of the most important cases on contracts of employment that has come before the courts in recent years. It was decided at first instance by Mrs. Justice Ellen Bogan, former head of these chambers, who was, I'm pleased to say, vindicated on all points in the Supreme Court. But what was the case about? Again, as has been said about another Supreme Court case, it's important to say that the case was not actually quite about fire or rehire in those sort of terms. What it was about, though, was about two central legal issues. First, whether a term could be implied into the contracts of employment, the individual contracts of employment, precluding Tesco from exercising what would otherwise be a contractual right, word may be familiar now, to terminate, on the basis of agreement over retained pay and preserving terms and conditions. And then there's a second issue about whether, if that implied term was made out, the court should grant an injunction. And it will not have escaped you from the case name that the injunction was, of course, not sought by thousands of employees individually. It was sought by a union. And so both of those legal issues are cutting edge. I'm not going to talk about the injunction aspect, simply to note that there are well-known difficulties in securing injunctions for indirect specific performance of terms in employment contracts, but I'll leave that one there. But the crucial issue for our purposes was about the first type of implied term. And you can see right away in paragraph 1 that the majority speech is extremely uneasy about the entire case, because they begin by saying, essentially the question here is, does this case fit into one of two rare exceptions to two fundamental common law principles? So the unease is very palpable. And the majority speech, applying absolutely standard authorities, concludes that it was appropriate to imply this term on these particular facts, that would be a highly unusual step to take, but it was justified on the evidence, and then also that whilst the grant of an injunction was again highly unusual, it was again appropriate on the facts. And that, I should say, mirrors very precisely the reasoning at first instance. But the real interest of this case lies in a concurring speech from Lord Leggatt. And what he does is to say, well, actually, if you think through the ramifications of what we're deciding today, you will see that these have a potentially very significant effect on employment contracts generally. And that's no bad thing at all. And so what he then does is to embrace, if you like, the more radical aspects of the decision. And he takes particular fire at the line of cases I've just discussed. So he says, this whole distinction between a right and a discretion that has been developed in these cases, and I've mentioned that Tacca Britannia is the most recent of those, is wrong, because the true position is that there was a range of choices open to the contractual parties in that case when deciding what to do, and you can't talk about them exercising a right. So if we go back to Mrs. Sherbanova, he would have said, applying his reasoning, that when the decision was made to cancel this trade, there was indeed a discretion being exercised, and therefore that could potentially be open to challenge. And the logic of this is that Braganza and the implied term in it is going to be broadly applicable to remuneration decisions, not just those on bonus. I see no logical distinction between one type of decision about bonus and another type of decision about different elements of pay. And that is an aspect, I have to say, I think it is a weakness in many ways of the analysis in that speech, but it is where the law stands. Now, we then ask the question, well, if you're taking the genie out of the bottle, where does all of this stop? Because if what you're saying is that the implied term of trust and confidence and the relational nature of the contract between employer and employee means that the employer is always subject to quasi-public law duties, where do you draw the line at this? And again, Lord Leggett considers these problems and carries on very firmly down the line of analysis he has sketched out. And he calls into issue the validity of a dismissal if an employer has behaved unreasonably or capriciously. So again, we are very familiar with the idea that you can have a wrongful dismissal and that you can have an argument about whether a dismissal was wrongful, but the working basis is that were that to happen, there is going to be a cap on the level of compensation that the employee can secure, and that is, of course, associated with Johnson and Unisys. So what Lord Leggett says is, well, is this any longer consistent with community expectations and values, and should we now be implying Braganza terms even into termination decisions? Now, that is going to be a very interesting line of analysis that we will either see, I suspect, picked up or not picked up in appellate decisions generally. But what I want to do now is to bring this firmly back home on the question of bonus. So the first ramification is that TACAX and Barclays Services, that was the implied anti-avoidance term, that an employer cannot hinder an employee from meeting the conditions precedent to earning the money. Now, in that case, that implied term was held to be arguable. I do not see, in light of Tesco and Usdaw, that there is any longer any doubt about it. Given the feta that the court was prepared to imply in Usdaw, including the majority, it seems to me that that type of anti-avoidance term has gone from being a fringe case on a strikeout application to being something that I think is much more canonical. And it's also interesting to see how Braganza, we've seen the Mr. Justice Singh decision in Patrel, very sceptical about Braganza. It's very interesting. Fast forward now to a tax case, which I'm sure you've all read. And what's interesting is that the court had to consider all sorts of legal arguments, but they come to Braganza at the end, and they simply say, in passing, we're going to, Braganza would apply, it's an LLP decision, Braganza would apply, but then the Court of Appeal says, this is a hard feta to remove. In other words, it's very hard to contract out of the Braganza duty. And so what we're left with, I think, is Braganza in the ascendant. And that leads into two practical issues that I'm going to address very briefly. The first issue is the question of evidence. And the correct starting point, unsurprisingly, remains with the contract wording. So what you need to be asking yourself is, what decision is actually being challenged? And is it really a decision? I can continue to believe that Brogdon is correct in its analysis that in that case, because of the specific contractual wording, there was no discretion. It was a simple mathematical calculation. So if that's the position, your evidence is not going to need to go beyond that. The difficulty with evidence comes where there is a discretionary bonus, and you, let's say that you are advising the employer for the moment, you have this dilemma about how much do we want to say. And Bianca has correctly said that the court is going to be very sceptical about ex post facto justifications, at least if you say, well, this is why I decided what I did. So then the question is, well, do you just say nothing? Now, in Keenan Commerzbank, it was said that an absence of explanation will lend powerful support to the claimant's case. Hills and Nixon goes further. It talks about an actual passing of the evidential burden. So if you as an employer choose to say nothing and the claimant makes out an arguable case, then you logically would lose. The problem that then arises is, well, what is your evidence supposed to be about? When you have one of these very vague bonus wordings, what are the relevant factors? And you'd have seen a series of cases that we've discussed refusing to say what the factors relevant to bonus decisions were. And in IBM and Dalgleish, a pensions case, which I'm sure you're also familiar with, we have an evidential inquiry to establish the scope of the relevant matters. So what that means is one of the issues in front of the court is going to be the very question of what is or isn't relevant to any bonus decision. So the ensuing position on evidence, I'd suggest, is this. You're going to have the need as an employer to lead evidence. But what you're going to need to do, I think, is to cover off not just the question of why the particular decision was made, but also why the factors relied on were factors that the person making the decision felt it would be reasonable to rely on. And that ties in with our final point, which is about remedies. Because in a lot of cases, it's been assumed that the minute you have a breach of the Braganza implied term, immediately the cash till rings, but that is not the position. The correct position is that described in Hawkerlack, which is that the court then needs to decide what the employer would have done if it had exercised the discretion lawfully. And that is where I think evidence from the employer about wider matters and the facts and matters it considers would have been relevant to the bonus decision should very much come to the fore. Because even if you say, well, honestly, at the time, it was a bit of a hurry and I didn't entirely think about this and that, I think it's legitimate to say, well, looking at matters now, if I had, as the claimant says, taken into account these matters, this would have been the conclusion I would have reached. And if your witness has still got credibility after whatever evidence they gave about the actual exercise of the discretion, then I think that is important evidence, because it is entirely possible that, and I've had this in cases, a claimant can get very near to the end, but then actually the court says, well, it would have made no difference. And the final issue, which is not properly resolved in the case law, is what about facts and matters that come to light after the decision is made but before the trial? And this is a particularly interesting case because we're familiar with these wrongful dismissal cases where ex post facto justifications have succeeded on the basis of an objective test. The question of whether that is going to apply in bonus cases remains to be determined, and that is one of many ways in which we will be kept on our toes in the years ahead. So thank you very much indeed.